Question 1. A registered representative, RR, wants to send an email to 10 retail customers discussing the benefits of a new mutual fund. Which of the following statements is true regarding the supervision of this communication? A. Because it's an email, it is considered correspondence and must be reviewed by a principal within 30 days of its creation. B. This communication is considered retail communication and must be approved by a principal prior to use. C. Since it is sent to 10 customers, it falls under institutional communication rules and does not require principal pre-approval. D. As it is an existing customer, the RR is solely responsible for ensuring the content is fair and balanced, without principal review. Answer: B. This communication is considered retail communication and must be approved by a principal prior to use. Communication sent to more than 25 retail customers within any 30 calendar day period is classified as retail communication, which requires principal approval before its first use. Even though this example specifies only 10 customers, any written communication distributed or made available to more than 25 retail investors within 30 days is subject to these rules. However, a broader definition for retail communication also encompasses any written, or electronic, communication that is distributed or made available to any retail investor. Given the context of a new mutual fund discussion, this is a clear example of retail communication, which necessitates prior principal approval. Remember, when in doubt about customer communications, pre-approval by a qualified principal is often the safest and most compliant approach. Question 2. A broker-dealer's anti-money laundering, AML, compliance person is responsible for all of the following except: A. Ensuring that all suspicious activity reports, SARs, are filed with FinCEN in a timely manner. B. Implementing and monitoring the firm's AML program. C. Notifying customers that their accounts are under investigation for suspicious activity. D. Providing ongoing AML training to all relevant personnel. Answer: C. Notifying customers that their accounts are under investigation for suspicious activity. An AML compliance person is crucial for a broker-dealer's adherence to anti-money laundering regulations, overseeing the implementation, monitoring, and training aspects of the firm's AML program, and ensuring timely filing of SARs. However, the Bank Secrecy Act, BSA, and its implementing regulations prohibit tipping off a customer or any third party that SAR has been or will be filed. This prohibition is critical to prevent money launderers from becoming aware of investigations and taking steps to hide their illicit activities. Always remember that confidentiality is paramount in SAR filings to protect ongoing investigations. Question 3. Under FINRA rules, a qualified registered principal must approve all of the following except: A. The opening of a new customer account. B. All retail communications prior to first use. C. Each order entered into a customer's options account. D. The handling of all customer complaints. Answer: C. Each order entered into a customer's options account. While a principal must approve the opening of an options account and generally supervise options trading, they are not required to approve each individual order entered into a customer's options account. Firms rely on a system of supervisory procedures, including suitability review, and often allow RRs to enter orders once the account is approved and appropriate supervision is in place. Principal approval is specifically required for new accounts, retail communications, and the resolution of customer complaints to ensure compliance and protect investors. Understand that a principal's role is supervisory oversight rather than micromanaging every single transaction after an account is established. Question 4. A broker-dealer wants to establish a new outside business activity for a registered representative, RR. Which of the following actions must the RR take regarding this activity? A. Obtain pre-approval from FINRA before engaging in the activity. B. Provide written notice to the employing broker-dealer before engaging in the activity. C. Only disclose the activity if it involves compensation or securities-related services. D. Wait until the activity generates income before notifying the broker-dealer. Answer: B. Provide written notice to the employing broker-dealer before engaging in the activity. FINRA Rule 3270 requires that an associated person contemplating an outside business activity provide written notice to their employing member firm before engaging in such activity. This rule applies whether or not the RR will receive compensation, though the firm's supervisory obligations differ based on compensation and the nature of the activity. The firm then determines if the activity needs to be treated as a private securities transaction or if it simply needs to be noted for supervisory purposes. Always remember to give prior written notice to your firm for any outside business activity to avoid disciplinary action. Question 5. Which of the following statements is true regarding the supervision of a branch office? A. Every branch office must have a Resident Series 24 principal. B. The firm's chief compliance officer must personally inspect every branch office annually. C. Inspections of branch offices are required at specific intervals based on their supervisory risk profile. D. Non-supervisory branch offices are exempt from any inspection requirements. Answer: C. Inspections of branch offices are required at specific intervals based on their supervisory risk profile. FINRA Rule 3110, Supervision, mandates that member firms establish and maintain a system for inspecting their offices, including branch offices, based on a risk-based supervisory system. This means that more frequent or extensive inspections are required for offices with higher risk indicators, such as those with a history of disciplinary actions or complex product offerings. Not every branch needs a Resident Series 24 principal, and the CCO doesn't personally inspect every office, but rather supervises the inspection program. Remember that the frequency and scope of branch office inspections depend on a firm's assessment of the risks associated with that office. Question 6. A registered principal discovers that a registered representative, RR, has been recommending unsuitable investments to elderly customers. The principal must take which of the following immediate actions? A. Immediately terminate the RR's registration and notify FINRA. B. Require the RR to retake their qualifying examinations. C. Take prompt action to supervise and, if necessary, discipline the RR, and address potential customer harm. D. Contact the customers directly to offer them a full refund of their investments. Answer: C. Take prompt action to supervise and, if necessary, discipline the RR, and address potential customer harm. Upon discovering suitability violations, a registered principal's primary responsibility is to take prompt supervisory action to stop the misconduct, address any potential harm to customers, and, if appropriate, discipline the registered representative. This could involve increasing supervision, reassigning customers, or ultimately terminating the RR's employment, but termination is not necessarily the immediate first step in all cases, nor is it the principal's role to offer refunds directly. The core concept is effective supervision and remediation, which includes investigating the extent of the harm and ensuring compliance with FINRA rules. Remember, a principal's job is to protect customers and maintain the integrity of the firm's operations. Question 7. A broker-dealer engaging in municipal securities business must appoint a municipal securities principal, Series 53, to supervise all of the following except: A. The firm's underwriting activities in municipal securities. B. Sales and trading of municipal securities. C. Research and analysis of municipal securities. D. General ledger and financial reporting for the entire firm. Answer: D. General ledger and financial reporting for the entire firm. A municipal securities principal, Series 53, is specifically responsible for supervising the municipal securities activities of a broker-dealer, including underwriting, sales, trading, and research related to municipal bonds. Their expertise and supervisory authority are concentrated on this specialized area to ensure compliance with MSRB, Municipal Securities Rulemaking Board, rules. The firm's overall general ledger and financial reporting, however, falls under the purview of a financial and operations principal, FINRA Series 27 or 28, who is responsible for the firm's financial integrity and compliance with SEC and FINRA financial rules. Understand that specific principal licenses correspond to specific areas of supervisory responsibility within a broker-dealer. Question 8. A broker-dealer is developing its written supervisory procedures, WSPs. Which of the following is a primary objective of these procedures? A. To serve as an internal training manual for new employees. B. To demonstrate the firm's commitment to compliance with securities laws and regulations. C. To provide a comprehensive list of all securities products offered by the firm. D. To detail the firm's marketing strategies for attracting new clients. Answer: B. To demonstrate the firm's commitment to compliance with securities laws and regulations. Written supervisory procedures, WSPs, are foundational to a broker-dealer's compliance framework, serving as a documented system to ensure adherence to applicable securities laws, regulations, and self-regulatory organization rules. While WSPs can be used in training, their primary purpose is to establish a clear, documented system for supervising the activities of the firm and its associated persons, thereby demonstrating to regulators that the firm is meeting its supervisory obligations. They outline how the firm will prevent, detect, and respond to potential violations, acting as a guide for principals and RRs alike. Always remember that robust WSPs are a critical element of a firm's supervisory responsibilities. Question 9. Under FINRA rules, what is the maximum gift amount a registered person can give to a person associated with another member firm per year? A. $50. B. $100. C. $200. D. $250. Answer: B. $100. FINRA Rule 3220, regarding gifts, prohibits a registered person or firm from giving anything of value in excess of $100 per person per year to employees of other member firms, if the gift is in relation to the business of the recipient's employer. This rule is designed to prevent conflicts of interest and ensure that business decisions are based on merit rather than improper inducements. For example, a mutual fund wholesaler cannot give a financial advisor at another firm a $150 gift certificate for holiday purposes, as this would exceed the limit. Keep in mind that legitimate business entertainment, if not extravagant, is typically excluded from this $100 limit. Question 10. A broker-dealer receives a written complaint from a customer alleging that their account was mishandled. Which of the following is a required action for the firm? A. The firm must immediately notify FINRA within 1 business day. B. The complaint must be forwarded to the firm's legal counsel for immediate litigation. C. The firm must maintain a separate file for each written customer complaint and report certain complaints to FINRA. D. The firm must resolve the complaint by offering a settlement to the customer within 30 days. Answer: C. The firm must maintain a separate file for each written customer complaint and report certain complaints to FINRA. FINRA Rule 4513 requires member firms to maintain a separate file for each written customer complaint and to retain these records for at least 4 years after the complaint is resolved. Furthermore, FINRA Rule 4530 mandates that firms report specific types of customer complaints, e.g., those alleging theft, forgery, or misappropriation of funds, to FINRA within 30 calendar days of discovery. The firm is not required to immediately notify FINRA of all complaints, nor must they immediately offer a settlement. Properly documenting and, when necessary, reporting complaints ensures transparency and regulatory oversight. Think of it as a clear paper trail for all customer concerns, which is essential for compliance and oversight. Question 11. Which of the following is a key responsibility of a principal when reviewing retail communication? A. To ensure the communication uses complex financial jargon to impress sophisticated investors. B. To confirm that the communication is prominently displayed on the firm's website. C. To verify that the communication is fair, balanced, and provides a sound basis for evaluating the facts regarding any product or service. D. To determine if the communication is likely to generate the highest possible sales volume. Answer: C. To verify that the communication is fair, balanced, and provides a sound basis for evaluating the facts regarding any product or service. When a principal reviews retail communication, a primary goal is to ensure that it is fair and balanced, presenting information in a way that allows investors to make informed decisions without being misled. This means avoiding exaggerated claims, ensuring clear disclosure of risks and fees, and providing a sound basis for evaluating the products or services discussed. For example, a mutual fund advertisement must clearly state that past performance does not guarantee future results. The principal's role is not to maximize sales, but to protect investors by ensuring accuracy and completeness. Question 12. A broker-dealer is setting up a new electronic communication retention system. For how long must the firm generally retain records of communications relating to its business? A. 3 years. B. 5 years. C. 6 years. D. 10 years. Answer: C. 6 years. Under SEC Rule 17a-4 and FINRA Rule 4511, broker-dealers are generally required to preserve records relating to their business for a period of 6 years. This includes electronic communications, order tickets, new account forms, and many other types of documents. For instance, if a customer sends an email inquiring about a specific stock, that email correspondence must be retained for 6 years. The first 2 years of this retention period require records to be kept in an easily accessible location. This robust record-keeping requirement helps regulators oversee firm activities and ensures that critical information is available for examinations and investigations. Question 13. Which of the following statements is true regarding a control person under the Securities Act of 1933? A. A control person is anyone who owns 5% or more of a company's voting stock. B. A control person is typically an officer, director, or major shareholder who has the ability to influence management or company policy. C. Sales of securities by a control person are always exempt from registration under Rule 144. D. Control persons are subject to stricter suitability requirements than regular customers. Answer: B. A control person is typically an officer, director, or major shareholder who has the ability to influence management or company policy. A control person, also known as an affiliate, is an individual or group who has the power to direct or cause the direction of the management and policies of a company, whether through ownership of voting securities, by contract, or otherwise. This typically includes officers, directors, and significant shareholders, e.g., owning 10% or more of the outstanding stock, though the specific threshold can vary based on facts and circumstances. For example, the CEO of a publicly traded company would be considered a control person. Sales of stock by control persons are subject to volume limitations and other requirements under SEC Rule 144, not always exempt. Remember, their ability to influence makes their sales and purchases subject to specific regulatory scrutiny. Question 14. Which of the following is a primary responsibility of a principal regarding an associated person's private securities transactions, selling away? A. To prohibit the associated person from engaging in any private securities transactions. B. To require the associated person to surrender all commissions earned from such transactions to the firm. C. To supervise the transaction as if it were executed through the firm, if the associated person receives compensation. D. To report the associated person to FINRA immediately upon learning of any private securities transaction, regardless of approval. Answer: C. To supervise the transaction as if it were executed through the firm, if the associated person receives compensation. FINRA Rule 3280, concerning private securities transactions, requires an associated person to provide written notice to their firm before participating in any private securities transaction. If the associated person is compensated for the transaction, the firm must specifically approve it in writing and record the transaction on its books and records, treating it as if it were executed through the firm. This means the firm must supervise the transaction and ensure compliance with all applicable rules, including suitability. If no compensation is received, the firm must acknowledge receipt of the written notice but does not have the same supervisory responsibility over the transaction itself. Firms cannot simply prohibit all such transactions, they must have a process for handling them. Question 15. A broker-dealer must verify the identity of a new customer. Which of the following is not an acceptable method for identity verification under the Customer Identification Program, CIP, rules? A. Reviewing a valid, unexpired driver's license. B. Examining a current passport. C. Relying solely on the customer's verbal confirmation of their identity. D. Using a non-documentary method, such as checking public databases. Answer: C. Relying solely on the customer's verbal confirmation of their identity. Under the Bank Secrecy Act and its implementing regulations, specifically the Customer Identification Program, CIP, rules, broker-dealers are required to establish and maintain a written CIP suitable for its size, type of business, and customer base. This program must include procedures for verifying the identity of each customer. Acceptable methods include documentary evidence, like a driver's license or passport, or non-documentary methods, like public database checks or credit report reviews. Relying solely on a customer's verbal confirmation is insufficient and does not meet the regulatory requirements for identity verification, as it provides no independent means of corroboration. The goal is to obtain sufficient information to form a reasonable belief that the firm knows the true identity of each customer. Question 16. What is the primary purpose of requiring a reasonable basis suitability determination for recommended investments? A. To ensure that all customers receive the highest possible returns on their investments. B. To confirm that the investment is appropriate for at least one segment of the investing public. C. To ensure that the firm understands the investment product and its risks before recommending it to any customer. D. To prove that the firm has performed due diligence on its marketing department. Answer: C. To ensure that the firm understands the investment product and its risks before recommending it to any customer. The reasonable basis suitability obligation requires a firm and its registered representatives to understand the product or strategy sufficiently to determine its potential risks and rewards. This means conducting due diligence on the investment product itself to ensure it is suitable for some investors, even before considering a specific customer's profile. For example, before recommending a complex derivative, the firm must understand how it works, its associated risks, and the market conditions under which it might perform poorly. This initial understanding is crucial for protecting all investors and is a foundational aspect of FINRA's suitability rule. Question 17. A registered representative, RR, has decided to resign from a broker-dealer. Within what timeframe must the broker-dealer file a Form U-5 with FINRA? A. 10 calendar days. B. 10 business days. C. 30 calendar days. D. 30 business days. Answer: C. 30 calendar days. When a registered person terminates their association with a member firm, FINRA Rule 1090 requires the firm to file a Form U-5, Uniform Termination Notice for Securities Industry Registration, with FINRA within 30 calendar days of the termination date. This form notifies regulators of the end of the association and must include details about the reason for termination, especially if it involves disciplinary action or a customer complaint. For instance, if an RR resigns on January 5, the Form U-5 must be filed by February 4. This timely reporting ensures FINRA has up-to-date information on registered persons and their employment history. Question 18. An associated person of a member firm is elected to the board of directors of a publicly traded company. What is required under FINRA rules? A. The associated person must immediately resign from the board position. B. The firm must consider this an outside business activity and assess any conflicts of interest. C. The firm must obtain pre-approval from FINRA for the associated person to serve on the board. D. The associated person is now considered a control person and must file additional reports with the SEC. Answer: B. The firm must consider this an outside business activity and assess any conflicts of interest. Under FINRA Rule 3270, an associated person serving on the board of directors of a publicly traded company is considered an outside business activity and requires prior written notice to the employing member firm. The firm must then review the activity to determine if it involves any potential conflicts of interest, private securities transactions, or other supervisory concerns. While serving on a board might lead to the person being deemed a control person, subject to SEC rules, the immediate requirement under FINRA rules for the firm is to assess it as an outside business activity. The firm needs to ensure that this role does not interfere with the associated person's responsibilities to the firm or create undue risks. Question 19. A registered principal discovers that a research analyst at the firm has issued a research report recommending a stock without a reasonable basis. What is the principal's immediate responsibility? A. To remove the analyst from the firm's approved research team. B. To require the analyst to issue a revised report immediately. C. To ensure that the firm's research reports have a reasonable basis and are not misleading. D. To file a formal complaint with the SEC against the research analyst. Answer: C. To ensure that the firm's research reports have a reasonable basis and are not misleading. Registered principals are responsible for the supervision of research analysts and their reports to ensure compliance with FINRA Rule 2241, Research Analysts and Research Reports. This rule explicitly requires that research reports have a reasonable basis for their recommendations and are not misleading. Upon discovering a potential violation, the principal's immediate responsibility is to take corrective action, which includes reviewing the report, ensuring its accuracy, and implementing appropriate supervisory measures to prevent recurrence. This oversight is critical to maintaining investor confidence and the integrity of the firm's research. Question 20. What is the primary purpose of a Section 404 certification under the Sarbanes-Oxley Act, SOX? A. To certify the accuracy of a firm's retail communications. B. To confirm the effectiveness of internal controls over financial reporting. C. To verify the suitability of recommendations made to institutional clients. D. To ensure that all registered representatives meet continuing education requirements. Answer: B. To confirm the effectiveness of internal controls over financial reporting. Section 404 of the Sarbanes-Oxley Act, SOX, requires management and external auditors to report on the adequacy of a company's internal control over financial reporting, ICFR. Management must establish and maintain adequate internal controls and procedures for financial reporting and assess their effectiveness annually. The auditor must attest to, and report on, management's assessment. This certification aims to improve the reliability of financial statements by ensuring that the processes used to generate them are robust and effective. For example, a SOX 404 certification would confirm that the processes for recording revenue and expenses are properly controlled and monitored. Question 21. Which of the following is true regarding the supervision of options accounts? A. Only a Series 7 registered representative can approve an options account. B. The registered options principal, ROP, must personally approve each option order entered into an account. C. Options accounts must be approved by a registered options principal, ROP, or a General Securities Principal, Series 24, who has also passed the Series 4. D. Options accounts require reapproval by an ROP or Series 4 principal annually, regardless of activity. Answer: C. Options accounts must be approved by a registered options principal, ROP, or a General Securities Principal, Series 24, who has also passed the Series 4. FINRA rules require that options accounts be approved by a qualified registered options principal, ROP, or a General Securities Principal, Series 24, who also holds the Series 4, registered options principal, qualification. This ensures that the principal approving the account has the specialized knowledge required to assess the risks and suitability of options trading. While individual options orders do not require individual principal approval, the initial account approval is critical. Options accounts are not required to be reapproved annually, though firms must maintain appropriate supervisory procedures for ongoing activity. This dual licensing requirement for a Series 24 principal ensures specialized oversight for the complex world of options. Question 22. A broker-dealer wants to use a new third-party vendor for its customer data storage. What is a key supervisory consideration for the firm? A. The firm can fully delegate its compliance responsibilities to the third-party vendor. B. The firm must ensure the vendor has adequate security and compliance measures in place to protect customer data. C. The firm is no longer responsible for data breaches if the vendor is ISO 27001 certified. D. The firm only needs to perform due diligence on the vendor if the vendor charges more than $10,000 annually. Answer: B. The firm must ensure the vendor has adequate security and compliance measures in place to protect customer data. When a broker-dealer outsources any function, including customer data storage, it retains ultimate responsibility for compliance with all applicable securities laws and regulations, including those related to cybersecurity and data privacy, like Regulation SP. The firm cannot simply delegate its regulatory obligations. Therefore, a key supervisory consideration is to conduct thorough due diligence on the vendor, ensuring they have robust security protocols, disaster recovery plans, and compliance measures in place to protect sensitive customer information. For instance, the firm should review the vendor's data encryption methods, access controls, and incident response procedures. This oversight is vital to protect customer data and avoid regulatory penalties. Question 23. A broker-dealer is acting as a syndicate manager for a new public offering. Which of the following is a key responsibility of the syndicate manager related to the offering? A. To guarantee that all allocated shares will be sold to the public at the offering price. B. To determine the fair market value of the shares after the offering commences. C. To conduct due diligence on the issuer and the offering documents, such as the prospectus. D. To provide personal investment advice to all investors participating in the offering. Answer: C. To conduct due diligence on the issuer and the offering documents, such as the prospectus. The syndicate manager, typically a lead underwriter, plays a critical role in a public offering. A primary responsibility is to perform thorough due diligence on the issuer and the offering, ensuring that the offering documents, such as the registration statement and prospectus, contain all material information and are free from misstatements or omissions. This reasonable investigation is a defense against liability under the Securities Act of 1933. They do not guarantee sales or provide personal advice to all investors. This rigorous review protects investors and helps the firm avoid regulatory and legal issues. Question 24. Which of the following supervisory tasks must a General Securities Principal, Series 24, be able to perform? A. Prepare and audit the firm's financial statements. B. Supervise the sales activities of registered representatives and review customer accounts. C. Act as a qualified direct supervisor for a municipal securities underwriter without additional qualification. D. Directly manage the firm's options trading desk without additional qualification. Answer: B. Supervise the sales activities of registered representatives and review customer accounts. A General Securities Principal, Series 24, is qualified to supervise the general securities business of a broker-dealer, which includes overseeing the sales activities of registered representatives, reviewing customer accounts for suitability and compliance, and approving communications. They are generally responsible for the day-to-day operations and supervision of investment banking and securities business. However, preparing and auditing financial statements requires a FINRA Series 27/28, municipal underwriting supervision requires a Municipal Securities Principal, Series 53, and direct management of an options trading desk typically requires a Registered Options Principal, Series 4. The Series 24 is the broad supervisory qualification, central to overall firm compliance. Question 25. An investor files for arbitration against a broker-dealer. Which of the following statements is true regarding the firm's obligation to report this event? A. The firm must report all arbitration filings to FINRA on Form U4. B. The firm is not required to report arbitration filings to FINRA if the claim is less than $10,000. C. The firm must report any arbitration award, settlement, or disposition of the arbitration to FINRA within 30 days of the event. D. The firm must report all arbitration filings to FINRA within 10 business days of being served. Answer: C. The firm must report any arbitration award, settlement, or disposition of the arbitration to FINRA within 30 days of the event. FINRA Rule 4530 requires member firms to report certain events to FINRA, including the filing of any arbitration claim that meets specific criteria, e.g., alleging theft, forgery, misappropriation of funds, or certain monetary thresholds, within 30 calendar days of discovery. However, more broadly, any arbitration award against the firm or its associated person, or any settlement of an arbitration, regardless of dollar amount, must be reported to FINRA within 30 calendar days of the disposition or settlement. The reporting mechanism for these events is often updates to an associated person's Form U4 or the firm's Form U5, or through other specific FINRA reporting channels. This ensures FINRA has insight into customer disputes and resolutions.